Hi everyone. Can everyone, I just took my screen off so that everyone can see me while we're waiting for it to load up. Okay, so I've unmuted my screen. I just want to make sure that everyone can hear me as well. We'll be starting in just 1 minute as people are joining. Looks like it takes a little bit of time. I think that given the system, it looks like it might take time for people to jump in, but okay. Okay, now we're having, today we have over 122 registrants for this webinar. So just going to wait for everyone to connect so they don't jump in halfway through. I know that sometimes there's little errors. So okay. Okay, I'll do my best to introduce Mr. Fortis and have him start. And then as people are coming in, they can join in, and I'll be able to help a little bit more with some of the technical issues that are happening. And we'll do our best to do that. This webinar bit using this Easy Talks system isn't one we're super familiar with, but we'll give it a shot, and hopefully it'll work out for everyone. So first off, thank you very much for joining us today in this webinar on commercial leasing. My name is Roy Bernhardt, and I'm the Executive Director here at Hummingbird Lawyers LLP. With empty offices located in the beautiful city of Vaughan and trendy Yorkville, downtown Toronto. So I have the honor of presenting Mr. Andrew Fortis today, founding partner at Hummingbird Lawyers LLP. Andrew is Hummingbird's go-to guru for commercial and residential real estate transactions, offering almost 20 years experience, a master's degree in real estate law, and one of the select few lawyers certified as a specialist in real estate in Ontario. In today's webinar, Andrew will be speaking to us live with information surrounding the issues of payment of commercial rent when that's in question, and a myriad of challenges that are faced by landlords and tenants during this COVID-19 pandemic. He'll also talk about how to deal with the fact that there's a declaration of emergency, the measures that have come into place in order to restrict distancing, physical and social distancing from one another, and how that's impacted businesses. If tenants are forced to close by the province, how can rent get paid? If tenants don't pay rent, how do landlords pay their mortgages? What are your rights, obligations, and remedies from both sides of the fence? What is everyone else doing? So we're hoping that today will help to expand your knowledge on some of those things, and hoping that Andrew will be able to answer some of your questions. The format for today will be that the first half of the presentation will be Andrew presenting some of his notes and some thoughts and some of his feedback from some of the questions that were presented already. And then the second half will focus on answering some of your questions live that come through on chat. Please feel free to ask any of the questions that you may have on chat while Andrew is speaking. and I will aggregate those questions and present them to Andrew during the second part of this webinar. All right, so without further ado, I'd like to turn things over to Mr. Fortis so that he can present. So give me a few seconds to flip things around, and welcome.
Good afternoon. Hopefully everyone can see me. I'd like to thank everybody for joining. This is my first webcast. I certainly hope that the Wi-Fi works. It all depends on whether or not my kids are playing basketball or if they're playing Fortnite and using all the Wi-Fi in my house. So here we are on April 1st, sort of a laughable joke. And we're hosting a seminar, and rent is due today because it's being the first of the month. The reason I wanted to put on this seminar is because I've been getting a lot of phone calls from landlords and tenants and a lot of questions about their duties and obligations today. And if you're watching this today, you're either a landlord or you're a tenant or you're a lawyer who acts for both, or you might be somebody who simply ran out of things to watch on Netflix, Crave, and Amazon and have nothing else to do on a Wednesday afternoon at 4 o'clock. I hope some of the information that you take out of this will help you and perhaps assist you with your leasing issues. So we know we're dealing with a global crisis and what can be termed a black swan event, which is it comes out of the dark. We don't know the extent of it, and we don't know what the true effects are going to be, and we also don't know how long it's going to be, but we look back and say, well, this was predictable. So by all accounts, we can reasonably expect to be in the current situation for the next several months. That's debatable, depending on who you speak to and what you read, but we know that this is not a permanent situation. And so the question really becomes, how are we going to deal with this interim period? Now, we know that the courts have been closed. We know that government assistance is changing, and it's evolving, and it's going to continue to do so because the entire situation is fluid. We don't know how much assistance is going to be actually coming down to small and mid-sized businesses, and that's to landlords and tenants alike. We've seen some of the things that the province have done in terms of their financial decisions, and most of their decisions have been regarding the relief that pertains to employment and to shelter when it comes to residential tenancies. And I think we can all agree that employment and shelter is paramount, and when it comes to commercial considerations, they're secondary. So where does that leave what I think to be the largest current issue, which is really a cash flow issue? This whole containment of being at home and what's going on with our commercial landlords and tenants is really an exercise in cash flow. So if you own a business, you know that your employees and your rent are generally the largest fixed expenses. And while the government is pitching in for employment for both employers and laid off employees, not much is being said about rent. And I follow this fairly closely because I don't have really much else to do. And this morning I actually got an email from CIBC and talking about the $40,000 loan program for qualifying businesses. In the email that I received, it says the loan is going to be interest-free. It's government guaranteed to pay for operating expenses if you're not able to defer as a result of COVID-19. I don't know what they mean by defer. Defer what? Also, we know that 25% or $10,000 of that $40,000 loan is eligible for complete forgiveness if it's fully repaid on or before December 31st, 2022. If it can't be repaid, it gets converted into a 3-year loan at 5% interest. It doesn't speak, or the email didn't speak about personal guarantees, so it may just be a corporate loan. I don't know, but in order to qualify, you have to be a Canadian registered company. You have to have a payroll. This is CIBC's. I can't speak to any other banks. You have to have a payroll of greater than $50,000 and less than $1 million per annum, and CIBC has to be your primary bank. The problem, of course, is if you're a small business owner, how far does really $40,000 get you? Not that far. So today's discussion is on commercial, both landlord and tenants, based upon what I'm seeing with my clients and their respective tenants and landlords. Now, I want you to keep in mind, this is not legal advice. This doesn't create a solicitor-client relationship. It's merely a discussion on the subject matter, and I hope you take it with that spirit in mind. So where do we start? Well, let's start with the law. We know when it comes to residential leases, the landlord's ability to evict has been suspended as bailiffs are no longer carrying out enforcements and evictions. The tenants can default, and the landlord is essentially handcuffed in enforcing the payment of rent or any other breaches under the residential lease for that matter. If I can do as an aside, I actually had a house closing where the tenant agreed to move out, and when the premier announced that evictions were not going to proceed, the tenants have been no longer moving out, which puts the agreement of purchase and sale into a crisis, but that's a separate issue. So I haven't heard of any mortgage relief for rental properties, and I think that on the residential side, there's going to be a real cash flow problem. What happens when the declaration of emergency is lifted, and what's going to happen, and where are the banks going to land with respect to those types of defaults? It's also uncertain as to how long we're going to be in this crisis and whether or not tenants are going to be able to make balloon payments when it's over. But when it comes to commercial leases, in terms of legislation, I haven't seen any changes. So where do we begin? We actually begin with the lease agreement. What does the lease agreement say about force majeure and as it pertains to rent? Some major retailers, and I don't represent any major retailers, but I represent tenants who have leased from major retailers, have a provision in their force majeure clauses that were modified when SARS came out in 2003, and they incorporated pandemics as an intervening event to suspend services. But most leases, if not all, under a force majeure will excuse the performance of the landlord to perform services, but it almost always does not relieve the tenant from the payment of rent. We also know that the province has suspended any limitation periods, but those only apply as they relate to statutes. They don't apply to private contracts. So the due dates in the leases should apply in terms of default and notice provisions, etc. So with the courts being closed, if you're a landlord and you want to enforce your contractual rights, you have to go to your contract, your lease, and see what it says. If your lease doesn't provide for any enforcement rights, then you're going to have to rely on the Commercial Tenancies Act, which provides for a reentry by the landlord upon 15 days of unpaid rent. So ideally, we have until really the 16th if you're a landlord and you don't have any enforcement rights under your contract. Ideally, for a landlord, when they go to do an enforcement proceedings, you want to do it by way of a court order, because if the landlord is wrong, or if the landlord was not entitled to enter, because the courts are going to consider this global crisis as an intervening event that suspends the payment obligations, the landlord's going to be liable for costs. We're really dealing with an unknown area right now. And if you're a tenant who's been locked out, you might not be able to get back in because you're going to need a court order for relief against forfeiture to get back in. And courts are only hearing urgent matters right now. Is it urgent? I mean, it is, but given the context of what's happening in the world and the limited resources of the courts, business operations, if you were asking me, probably don't cut it as urgent. So what are some interim considerations to think about given the current state of the law? The first thing I tell clients, whether you're a landlord or a tenant, is check your insurance policy. Check to see if you have business interruption insurance. If you don't, some insurance policies may also include a broadly worded enough loss of attraction or even pollution provisions, which might possibly trigger insurance protection, which would assist with the rental obligations during this crisis. If insurance doesn't work and you're not going to be provided in coverage, then to my mind, the lease sort of on the interim basis gets divided into those leases for which we have essential businesses and those that we don't, okay? So, and this is more in the context for a landlord. If the property is going to be considered an essential, if the use of the tenant is considered an essential service, landlords need to take into consideration the following when they're keeping their buildings open. A landlord must have the right to control access reasonably in good faith to their buildings, but this raises questions. What is that access? Can they access the tenant's customers, their clients, their suppliers, their employees, the common areas, or to the building in general? And if so, to what extent? Can tenants still gain access to the premises to retrieve files and laptops in the event they need access, in the event access to the building is restricted? Can a landlord inspect a tenant's customers, clients, suppliers, and employees for an illness as they pertain to protection of their other tenants? Could customers and clients and suppliers and employees' privacy be affected by the landlord's response to the COVID-19? and the control of the building? Or is the landlord permitted to enter a tenant's premises without permission in order to disinfect it and clean it? As a response to COVID, are tenants able to close down their businesses, even if they're considered to be an essential service, and reduce the operating hours if the lease requires them to be open for specific periods of time or days? And what obligations does the landlord have to keep the building clean and safe? And can the landlord limit or reduce services to a building? And these are all things that you need to take into account and look at your lease agreement. And from a tenant's perspective, whether if you're not essential and you're closed out, check your insurance policy, not so much for the business interruption, but some policies require you to notify your insurer if there's a change of circumstances, because you don't want to void the policy. If you're not at your lease premises and if there's a flood or a fire in the building, you don't want the insurance company to turn around and deny you coverage because you didn't call them to tell them that you've been closed because you're not an essential service. Irrespective of whether or not you're an essential service, I think it's fair to say the rent is due, okay? But that is, I say that without knowing what the courts are going to do because the courts are closed. It's fair to say that given a global pandemic, the world is somewhat being more lenient with each other and showing a softer side, which is really nice to see for a change. I mean, after all, we are in the middle of a global pandemic, and I think the governing principle is to act reasonably in good faith in coming to solutions to the issues that we are presently facing. We don't know how the courts are going to decide because they're closed, okay? Will they, when the courts open, look at a landlord that didn't give any leeway, or look at a tenant who simply refused to pay rent and who insisted on the strict performance of their contracts with a hint of disdain? We don't know, but it's out there, and we won't know until there's actually a court decision. And I wanted to speak very briefly about frustration of contracts, because this has been floating around. Now, we can get into an academic discussion as to whether or not a lease is a contract or it's a conveyance of land. If you ask me, I fall on the side that it's a conveyance of land more than it is a contract. I've been wrong. As a matter of fact, the Supreme Court disagrees with me, but I disagree with the Supreme Court. They think that leases are more contracts than conveyances of land. I'm a real property lawyer, and so I think land is more important than the contract. But be that as it may, in short, a lease cannot be frustrated for an intermediate period of time and then be considered frustrated. Because keep in mind, if it's a frustrated contract, the agreement comes to an end. And typically that happens when you have, let's assume for the moment we're buying and selling a car and the car explodes. Well, the contract simply can't go through because it's been frustrated. But in leasing obligations, the building can burn and it's not considered a frustration of contract. So if you've been considering that avenue to go down there as a frustration of contract, I don't think you're going to find any relief down that road. So what are some practical considerations and general understandings? When I act on a lease for a client, I typically tell them these are like marriages. They're not as long as marriage. Well, sometimes they're longer than marriages, but they're long-term relationships, and a lease should be reviewed as such. If you have a reasonable relationship, you can have a reasonable outcome. If a landlord doesn't have any sympathy for a tenant and doesn't want to work with them, there's a real good chance that the tenant's going to have to close for business, and that's going to leave the landlord in a very difficult position because they're going to be left with retaining whatever security deposit they have. They're going to be left with a lawsuit to sue for the difference, and that, who knows when that's going to happen when the courts do open. And when they go to sue, it's going to be against the tenant and any personal guarantors that they may have if they did it. And in all likelihood, if you're going after the personal guarantors, they're going to file bankruptcy. And then, of course, if you're a landlord, you're going to have to hire your realtors to release the space. You're going to have to pay commissions. You're going to have to deal with new fixturing dates, fixturing periods, leasehold improvements for all what hopefully, and I hope, is only a short-term hiccup. Okay? And we know, and this is what I tell my landlord clients, the tenant isn't paying because they don't want to. They're not paying because we're in the middle of a global pandemic and everyone is expected to stay at home. So they're not doing it because they want to. So I picked up the newspaper today and I read a couple of articles, and what I saw was RioCan one of Canada's largest retail investment trusts, which derives more than 50% of its revenue from the GTA, has said it's going to grant an automatic 60-day interest-free rental deferral to independent commercial tenants who ask for it. So if you are a big retailer, there's no hope for you. So that's nice to see a big landlord helping out their tenants like that. Now let's flip to the other side, and this took place in the States. The Cheesecake Factory, they have 300 locations. They called up the landlord today and said, we are not paying rent, our restaurants are closed. Too bad, so sad, if you will. And my understanding with the Cheesecake Factory is that they have a lot of locations with the same landlord, and hopefully that landlord can withstand the storm. So, and I also read that large landlords are giving breaks to smaller tenants and not to the larger ones who are asking for relief when they don't desperately need it. And actually, just prior to this webinar, I got a phone call from a client who told me a story. He's a landlord. He has a tenant that has a drive-through restaurant. And the tenant called him up and said, listen, I'm slow on business and I only have drive-through. My client drove to the drive-through and said, there's a lineup down the street. You're actually probably doing better than you were if you were open regularly. So don't try and use me, the landlord, as a way to make more money in your pocket. So there's going to definitely be a balance. I also, and I forget where I read this, but I read this yesterday, and it talked about a survey. It was a small survey sample, so take it for what it is, and it says that 24% of businesses can last a month without paying rent, otherwise they're going to be forced to close the doors. 43% responded that they can last 3 months and then they're going to have to close the doors. So what does that mean? To my mind, it means in 4 months we're going to have close to 80% of the businesses gone if everybody enforced the strict provisions of the leases. So I think now's the time to get a little creative and come up with some remedies. I mean, listen, if you're a tenant and you want it out and you don't have a personal guarantee, this is the opportunity to do so. And if you're a landlord and you wanted an opportunity to get rid of what would otherwise be a bad tenant, now's your opportunity to do so. You just enforce the strict terms of the lease. But I think for everybody, they see this as a no-win situation for anybody. So I think we all have to get a little creative and figure out how we're going to get through this. So I'm going to tell you what I've been seeing with my clients. But the first thing you need to do is you need to have a conversation with your other party. If you're a landlord, speak to your tenant. If you're a tenant, speak to your landlord. Nobody appreciates silence, and nobody appreciates finding out last minute of current hiccups. I mean, we're already inside a state of uncertainty. Further uncertainty doesn't help. So have the discussion with your counterparty. Find out what's going to happen during this non-payment period and what's going to happen. And you need, like I said, you need to get creative. So what have I seen? I've seen a rental deferral. I saw a rental deferral with a payment of just TMI, even though tax payments have been suspended in the City of Toronto. I know the City of Vaughan is not enforcing penalties, so that's sort of an indicator of don't pay your property tax. We won't charge you arrears, and when you get back on your feet, we'll collect it. On the one that I saw, the deferral, they deferred 3 months rent, and they said those 3 months we will pick up, spread out over the following 6 months. So they got a deferral for April, May, and June, and then they're making up those 3 months payments at 50% over the remaining period. So that's not a bad idea. I also heard one creative solution, which was a rent reduction with the landlord actually becoming a partner with their tenant and saying, okay, we're going to do percentage rents. So that way the tenant knows that they only have to come up with a certain fixed amount, and they've negotiated a split of revenues with their landlord. And it also keeps the tenant honest because they're going to see how much revenue is actually coming through the premises. In terms of rental abatement, I have seen reductions of rents. I have not seen any abatement or forgiveness. I've seen people saying, tell you what, the next 3 months are uncertain. I won't charge you for April, May, and June, and what we'll do is we'll add those 3 months onto the end of the lease. So it's sort of like a quasi-extension, if you will. That may or may not work for a lot of people because essentially the landlord is going to lose the 3 months, but I think lines of partnership between the landlord and the tenant on that. Another suggestion that I've seen is using the security deposits to keep the landlord afloat in the interim, with the idea being that the deposit will be replenished over time. As I've mentioned, I have not seen any landlords giving full forgiveness of rent. I've heard of a few lockouts where landlords are being very strict in their enforcement, and the problem with that is the phone call that is made right after the landlord that they are going to enforce the lease is they call their trustee because they're going to file bankruptcy. And I think in those instances, the landlord either wanted the tenant gone or the tenant, or rather the landlord is not thinking, if you ask me, clearly with a long-term view, because if you have a tenant and they're a good tenant and they pay rent, and it's because of this global pandemic that they're not paying rent, why aren't you almost better off with the devil you know than the devil you don't know? So I have seen landlords coming down very hard on their tenants. The other thing landlords need to keep in mind while they go through this period and negotiation is their financing commitments. I act for landlords who get bank financing and they have certain covenants to the banks. Some of the covenants are you're not allowed to make amendments to the lease without the bank's consent, or sometimes inside the financing documents there's an income to debt ratio. And so if there's you have to keep that in mind, because if you're going to offset your income to debt ratio, you certainly don't want to be offside with your lender. I think if you ask me, the best approach is to review this on a month-by-month basis. We don't really know how long we're going to be here. I have young children and they go to school, and I sort of gauge it by the school boards who are saying that the schools are going back in May. I think that's a little ambitious. I think that, who knows? It depends on what you read. But the point being is, I think the best approach is to assess this on a month-by-month basis. It's very difficult to plan because, like I say, everything is fluid, and we don't know what's going to happen in May with the province and the federal government as to whether or not they are going to give any relief to tenants and landlords. Also, the other thing too is, if you're a landlord, you may want to consider reviewing your tenants' financial statements. I mean, if they're shut down, they're shut down, but if they're an essential business and they're operating, you may want to see their financial statements to see how much of a drop they had from, let's say, mid-February to mid-March, from mid-March to mid-April. I think that will give you a pretty good idea of how bad these tenants are hurting. So, if you are going to enter into some sort of arrangement for the deferral, the single greatest thing you're going to need is communication with your counterparty and writing. You want to memorialize your writing, and you don't want to forget to include the following: how much relief is going to be provided, for how long, how that relief is going to be repaid, if any interest is going to be charged on that. And one other thing to take into consideration is, if there's a breach, if you decide to do a rental deferral with recapture for, let's say, 2-3 months after the declaration of emergency is lifted, or any period beyond that, you want to address the provision saying, if there is a breach during that period, what happens to all that recapture? Does that deferral amount get recaptured? Does it get accelerated? So those are some of the considerations that you want to think of, but if nothing else, you definitely want to have whatever arrangements you come in with your counterparty, landlord or tenant, you definitely want to have it in writing. Our office has been drafting quite a few tenant assistance agreements which speak to that, and it's attached as a schedule. It's not an amendment, but it's kind of an amendment to the actual lease agreement, and those are all memorialized and become a part of the lease. So that's really all I have to say. That's all the information I have. I have a couple of questions that have been that were sent in earlier. One of them was talking about, the impact on tenant obligations, but also landlord strategies. Landlord strategies are, you got to work with your tenants. If you don't want them out and you want to pay your bank, you got to work out something to cover at least your mortgage obligations. I'm not suggesting for a moment you want to give a complete gift to your tenants, if you want to work with them. And so I gave you a couple of strategies as to how to work together. Unfortunately, I think this is one of those situations where it's a lose-lose situation. And I think it's just bad for everybody. It's bad for the tenants because if you go out of business, you got to file bankruptcy. If you personally guaranteed the lease and the house in your home is in your name, you're going to lose your house. And if you're a landlord and you kick out your tenants and you can't pay the mortgage payments, the bank's going to come in and they're going to take your valuable property. So I think the best course of action is for people to talk to each other and get very creative. Sometimes you don't have to get creative, but get creative in figuring out the strategies. The next question I have is, although not specific to commercial leasing but similar nature, what can condo owners do during occupancy when they're not considered tenants? That's a great question. So I would look at the occupancy agreement. Occupancy agreements are typically licenses, and licenses could be revoked at any time. But I think if on that, it's tied into an agreement of purchase and sale. And it's been my experience that courts have more sympathy for buyers than they do for heavy-handed builders who throw people out. So I don't have an exact answer for that. Again, I would have to take a look at the occupancy agreement, but that's another place where communication is key and people coming to arrangements to work things out. Because keep in mind, if you don't pay your occupancies during a condominium closing and you get thrown out, you're also in breach of your agreement of purchase and sale. So you're going to forfeit all your deposits. You're also going to lose whatever equity has been built up in the premises. And if we end up in front of a court, 6 months from now, if you ask me, I don't think courts are going to look too kindly upon a landlord because at least inside the interim occupancy, you're paying your common elements, you're paying your taxes, which have also been suspended, and you're paying a notional amount of for mortgage. So hard to say, but I think that people need to work together to resolve that. The next question I have is, talking about business interruption insurance. Do we know anything about these insurance clauses and how they're going to assist? We looked at our insurance policy. We were not covered. Being lawyers, we try to get creative sometimes. And one of the things we looked at was whether or not the premises can be considered contaminated, which would trigger coverage. The insurance company flat out denied that. And I don't know if that's exactly true. And I wonder if, the contamination is, considered to be physical damage. Now, certainly we're not going to be suing our insurers. We just don't have the financial wherewithal to take on an insurance company. But it would be interesting to see whether or not insurance companies are taken to task and seen as to whether or not they should have provided coverage. We'll see. The deferrals and sorry, I apologize. I thought I turned off my reminders. The next question I have is, what's the difference between a deferral and an abatement? Really, an abatement is a gift, whereas a deferral is saying we're just taking the amount that you're owing and we're just going to defer that amount. I guess abatement is more like a forgiveness, if you will. So if you can defer, if you're a landlord and you're looking at deferring, you want to figure out how much is going to be deferred and how much is, and when that is going to be paid back and on what terms. The next question we have is, what if my landlord forces me to shut down my business by locking the building? That's a great question. Again, I would say look at your lease. If you're considered an essential business, what are the landlord's rights to shut down the building? Because if the lease requires the landlord to provide services, I don't think they have the ability to lock you out if you're otherwise a good staying. It depends on what the lease says. Some leases talk about the control of the building, and they might be able to control it to a large extent. I know one of our landlords has restricted access, but there's still access to our building. We're still getting our mail. Couriers can still come to the building. They can use a buzz code. They're stuck inside the front alcove of our building, but the building's still open and operating. And so that's well within their leasing rights and their ability to control the building. So I would take a look at the lease agreement and see what it says, and then I would contact your landlord and say, I need access to my building. I'm still an essential service, and work out a mechanism for you to continue to have access to your building. The next question is, what are essential business? We're an essential business, but our landlords are not providing us with any cleaning services. Oh, that's a great question. So how would I deal with that. I look at the lease agreement, and if the landlord's obligated to provide cleaning services and they are not, then you're going to have to hire your own cleaning services. You should keep receipts and then discuss it with the landlord and talk about, most leases provide that rent can't be set off. I would speak to the landlord about it. Maybe the landlord is saying, fine, our cleaning company simply won't come in, so you go ahead and you get your own and you do it, and we'll cover the cost of it. And if not, unfortunately, you may end up with a small claims court litigation on your lease, trying to collect back the cleaning costs. Because if you're still operating, you're going to need that place to be cleaned, and if the landlord's either not providing it contrary to the lease or somehow preventing it, that's going to be a separate leasing consideration that's going to have to be dealt with. But again, I would have the conversation with the landlord as to what can be done in the interim period. Where a contract or lease occupancy agreement is silent on force majeure can apply in this situation. Well, we know it doesn't apply to rent, and I haven't seen any statutes that grant tenants the right to not pay the rent, unless, of course, the government issues a declaration saying that commercial rent is not payable. I highly doubt that is going to come. I think it's going to come more, I'm hoping it comes more in the relief from the federal government, given that if this thing continues for 4 months, we're going to lose 80% of our operating businesses in this country. So if it's silent on force majeure, if you're a landlord, it comes down to your lease agreement. And I think the other thing that we're all learning in all this is that some of us were very casual in the agreements we made with our tenants and our landlords, and they were either handshake deals or very loosely put together deals. And so this black swan event is making everybody, or should make everybody, revisit the agreements that they have, or on their next agreement, not so much to deal with a pandemic, but to make sure that issues that are arising out of this, such as access, such as cleaning services, need to be contemplated in our lease agreements. And then another question we have is, would I advise against a tenant signing a lease at this time? What can we add to the lease given these unknown times? That's an excellent question. So I'm actually concluding a lease today, oddly enough. The challenge that we had is we had a signed offer to lease, and the signed offer to lease provided for possession to take place on March 15th. That got extended to April 1st. And so we only had a 1-month fixturing period, and then we had a 1-month fixturing period, and then we're up and running. And the landlord was really great, and the landlord turned around and says, tell you what. Oh, and the other thing was my tenant, the tenant was being kicked out on March 31st. They needed a place to get in. So what ended up happening was, and great landlord, they got it. They were like, we don't want to go through this because we just went through the fixturing. But what we're going to do is we're going to give you occupancy on April 1st. You're going to get fixturing for 3 months, for 30 days rather. So the whole month of April is going to be rent-free. And we are going to give you 3 months of just TMI and utilities, and you're not going to have to pay any rent. And this was by a very small landlord. And so the tenant was like, great, because that essentially gives him 4 months to figure things out. And like I say, it's a month-by-month situation, if you ask me. And so now we're going to get to our last question. If the lease expires before a business is permitted to reopen, either by government or by a governing body such as a college, would frustration of contract apply to the remaining period of the unexpired lease? Wow, that's a great question, because frustration doesn't apply to a temporary, and so I'm going to say no, because if the tenant exercised, let's assume for the moment there was extension or renewal rights. If those extension rights or renewal rights were exercised, the lease would still continue. And on top of that, as I've already said, an interim interruption does not amount to frustration. It would have to be a permanent. Here's a really bad analogy. The planet gets hit by a meteor, and we're inside some nuclear cloud for the next 200 years. I think that would be a frustration of contract. Anyways, thanks very much. I hope everybody walked away with a little something today. It's been a real pleasure speaking to you. And if you're to take one thing away from this talk, is be reasonable, talk to your counterpart, okay? Work out some sort of arrangement. And if you have any questions or if you need assistance, shameless plug, feel free to give me a call for a consultation. Thanks very much, and I wish everybody a wonderful April 1st, and I'm going to pass it back to our moderator, Roy Bernhardt. Thanks so much. Bye-bye.
Hello, everyone. Again, I'd like to thank you for joining us today in our presentation, and thank you very much to Mr. Andrew Fortis for presenting that and putting that together and putting on a suit and a tie in these times, which I think is fantastic. The presentation is actually available on YouTube as a webinar. We've recorded the presentation and we'll present it afterwards. But again, thank you all for coming and joining us today at 4 and throughout this 45-minute segment. And you know, we at Hummingbird Lawyers miss you all very much, and can't wait to be able to service you guys in person and just be able to give everyone big hugs. So from all of us at Hummingbird Lawyers to all of you, and on behalf of Andrew Fortis, thank you very much for joining us today. Have a wonderful, wonderful afternoon. Stay safe and stay healthy.